All right, Joe Norman.
Morning, Judge. Your Honor, the state filed a motion with a request for a specific trial date in this case. And it is a simple request. The state is asking for February 29th of 2016 to be the trial date for this case. And we are before the court today asking for that date, and we're asking for it for the victim. We're asking the court to enforce the Tennessee Constitution and the victim's rights to be trial. We're asking the court to allow this victim to be free from harassment and intimidation. And while I know that these defense attorneys are not intentionally trying to harass the victim, this court process that she is trying to endure, that is what it is doing. And the continuance that was granted, it is creating a burden for her, which we described to the court in the affidavit, but it is almost indescribable what she has been through and what she will have to be through. And Your Honor alone is the only person that can enforce the Constitution and enforce her right to a speedy trial. And we are asking Your Honor to consider the information that the state put before you, and consider that this victim is making this one request. The defense has made 3 requests for continuances up to this point. She is asking for this one request, and we are asking that the court set this case priority. And I know that the attorneys have other cases scheduled. I completely understand that. And attorneys will always have other cases scheduled. There's never really going to be a good time unless we set it a year from now where it's not a conflict for someone. But it's not these attorneys that is making the request of Your Honor. It was Mr. Vandenburg. Mr. Vandenburg asked Your Honor to continue the November 30th trial date. That was the date the state was ready. That was the date the victim could be there. And he comes before you after firing his previous attorneys, hiring new ones. And he is hoping that their conflict in trial will be enough to push this case off further. But at some point, it has to end. At some point, the continuances have to stop. And the state is asking, because Your Honor does have the authority to set it priority. He doesn't have the right to have 3 attorneys, and he has the right to an attorney. And we're just asking that you set the trial date on February 29th.
All right, response.
Good morning, Your Honor, please.
Morning.
Your Honor, for the state to suggest that Mr. Vandenburg is hoping that the trial calendar of his counsel gets this court date moved, that's just disingenuous. Mr. Vandenburg isn't hoping that. She doesn't. Ms. Norman doesn't know what Mr. Vandenburg is hoping for. Your Honor, the last time we appeared before this Honor's Court, Your Honor gave us 3 dates, March the 28th, April the 4th, and April the 11th. All 3 of those dates work for Mr. Vandenburg, work for Mr. Vandenburg's counsel. We have stressed that to the state today. We have stressed that with Mr. Batey's defense counsel. Those dates work. Those dates are convenience for the parties, and I think those dates ensure Mr. Vandenburg's right to due process and his right to a trial by a fair and impartial jury. And Judge, we can sit here and we can try to cast blame and we can try to say that it's somebody's fault. The victim had a speedy trial. The victim had a trial. That trial was set aside because a juror chose to make a mockery out of the jury selection process. She had a trial. We're here to retry. And unfortunately, for the victim, there's a process in any trial, and there's a process for this second trial. And we understand it may be inconvenient for the victim, and the victim does have a calendar based on the affidavit of Ms. Norman where she's going to be in exams the week of the very date that their case is to set it in June or July. if the goal is to not inconvenience this victim and interfere with her studies, I can submit to the court that, again, we are here today, we are here to try the second trial of Mr. Vandenburg and Mr. Batey because of actions not done by the defense counsel, not actions taken by the state, not actions taken by the victim, but the actions taken by a juror who failed to do what a juror should do when he sits in that jury box, he or she sits in that jury box. That's why we're here. So to try to cast blame on someone sitting at this defense table or try to cast blame on Mr. Vandenburg and say, well, they may not be intentionally harassing the victim, but they're harassing the victim. We're not harassing the victim. We're simply entitled to due process, and we ask the court to schedule it on March 28th, April the 4th, April the 11th. We can pick the jury. That's good for Vandenburg. I don't want to speak for Mr. Batey's lawyer. And the victim may very well, we have to keep in mind, there are two other co-defendants that's yet to have trials set. If they want to try one in February, there's two more individuals they can set for trial. And the victim, I believe, is made aware that, hopefully they've been made aware that there's possibly this trial and two other trials that she would have to make herself available to. So we would ask the court to set it March 28th, April the 11th, April the 4th. Judge, before I forget, in our response, we do mention that we have a vehicular homicide case scheduled in Sullivan County, Tennessee. It predates this in time, it predates this in setting, and that's one reason why those dates work, but there is a special judge that has been designated to hear that case. I'm not saying that one should take precedence over the other. Courtrooms have been arranged, and I understand that we're picking a jury from Chattanooga, and there's accommodations there also, but we do have that trial set that would not make us ready for this trial on that date. Again, that is why those dates that this court gave us at our last court appearance, all three of those dates work for our calendar. 1 second, please, Judge. I'm sorry, Judge. Mr. Reagan just pointed out he does have a federal trial set. It looks like it's a 31 count indictment stemming across the whole United States federal trial in the Eastern District Court of Knoxville. Again, we're not asking for any continuance or delay. We're just asking that the court set it on one of those dates the courts have given us prior to. If not, and it's out of convenience for the victim, set it after the victim concludes her class schedule. Thank you.
In that federal wire fraud case, Judge, it's set March 1st.
All right.
Good morning, Your Honor. With respect to the state's motion, there is a hurdle that has occurred for Batey counsel, and that is, Your Honor, Ms. Powers, my associate, who was here for the first trial, who is now Ms. Jones, is leaving our firm at the end of the year and will not be returning. The hurdle is, Your Honor, that this case is significant, and obviously significant because you have three of the most experienced trial attorneys in the district attorney's office prosecuting this case. You have two very fine lawyers for Mr. Vandenburg seated here, and a fine lawyer in California, which is three lawyers. And Ms. Jones leaves me with trying the case by myself. And Your Honor, I believe it's too much to handle. I have actively sought or begun seeking co-counsel. Mr. Batey is indigent. An appointment would be, appointment of co-counsel would be something we would ask the court for. I spent a good deal of time yesterday afternoon speaking with the AOC about this, and I have a telephone conference today for additional discussion as for appointing co-counsel. So I think having co-counsel is in this case required, and it's we only have to look at these two tables and these other two parties to understand that. I think setting the case in April would certainly give co-counsel time to get on board and get caught up to speed. We would work very hard and diligently to make that happen. That is a concern, if Your Honor were considering the week of February 29th, whether or not co-counsel could get up to speed. But I think April, yes. One hurdle I have shared with the state, personal hurdle, Your Honor, I've shared with the state, Mr. Vandenburg's attorneys, is that I'm scheduled to be out of town with my family March 19th through 26th. I'll be getting back that evening. If Your Honor, of the 3 dates you gave us last time we were here, the 28th of March, April 4th, and April 11th, my very strong preference was to pick a jury the week of April 4th, because that would allow me to get back in town, give me a week to get back in motion, and then leave, start picking a jury on April 4th, and then start the trial. So for Mr. Batey, those are the concerns, Your Honor. We believe they're legitimate concerns, and providing him the very best legal assistance that can be provided.
All right, final response from the state.
I reiterate the statement, while I understand what Mr. Robinson is saying, my understanding that Mr. Robinson is not in a law firm which is composed of just himself. There are other attorneys in his firm, but Mr. Batey is not entitled to 2 attorneys. This is not something where there is a quota at the minimum, and we have multiple attorneys, and we're talking about adding more attorneys and individual conflicts of these attorneys. Again, this is not at the victim's convenience. It's not convenient. None of the trial dates are convenient. She's in a PhD program. It determines what her career will be. And this trial could put that in jeopardy. The state is asking to enforce the victim's right to a speedy trial. We are asking for February 22nd.
All right, well, what I'm going to do is look over the state's affidavit in motion and defense response and let you know in just a matter of minutes. I do want to take up 1 or 2 other matters before I take this break. And I see Mr. Ridings, Mr. Nevin, they're anxious to come up. So I'll let you know in just a matter of minutes.
Mr. Nevin's calling with regards to the they have the vote now.
Okay.
Judge, on behalf